We're going to talk about managing risk with NFTs instead of the legal topics, really just a much more practical approach to it. I'm Steve Massour. This is Omri Bouton, and I can't wait to hear what you have to say.
Okay. Hi, everyone. I hope you are having a good time here in New York. Personally, I'm a bit exhausted. I find the events, the main event and the satellite event really great, but also exhausting. So today I'll be speaking about risk. Originally, I wanted to speak about intellectual property because I find it very interesting. But given that most of my clients, and now I'll go into what I do in the day-to-day, often approach us, once the risk has already realized, I thought of focusing this talk, on trying and help some of you that are building products and services out there in Web3 so that hopefully, that risk doesn't realize, or if it does, you've mitigated some of it. So I'm a lawyer. I'm based in London. I'd say I'm a blockchain Web3 lawyer, which is, it kind of says everything and nothing. But what it means is that effectively, as a Web3 lawyer, I combine intellectual property with other areas of law and practice. So we deal with financial services regulation, anti-money laundering, and also gambling regulation, which, as we will see, is more relevant than many people think. So, when we talk about risk, I think generally we all have the same understanding in that it means that there is an exposure to something unpleasant happening. And there are different types of risk, of course. There is bad risk, which means you're incurring that risk of something bad happening for really no exposure to value. Or there is good risk where you're taking some risk because on the other end, you could potentially go through an experience that is educational or potentially have financial success when exploring, say, an uncharted territory. And I do think the Web3 is very much an uncharted territory, and it's, if you want, the next exploration into the digital space, which is what makes risk so important. And often, people that operate within the space try to mitigate some risk, but some of the risk is not as obvious as we will see. So really, this whole talk stems from these concepts, from this idea, which I would like you to take with you. And I know it sounds very simple, but to put it in practice is actually quite different, which is taking risk is not the same as not being aware of it. And great, I think, executive and clients that I work with, which are very successful, know how to handle risk and they know how to take decision and they're comfortable with it, depending on the risk profile. But then most often than not, we help clients, trying to mitigate risk, and that means maybe they have not dealt with their taxes properly, maybe they have designed a product that is, a security, or maybe they are releasing, say, a game or a product that could fall under gambling. And once the product is out and the regulator is interested in you, then it becomes much harder to comply. So, a lot of talks about risk, law, and regulation, and you'd think that maybe I'm trying to deter you from entering the space. It's the complete opposite. I would say that I'm more of a degen or a degenerate than an actual lawyer. I'm, very enthusiastic about the space itself. But again, like this whole talk wants to focus less on the technicalities and more on the type of risk that the different players within the Web3 space tend to, neglect. So if we start with, the obvious one, regulatory risk. We've all heard about, securities law, what's a security, what's not a security. And I think that, generally now there is a good understanding within the Web3 community that this is an area of risk. However, unfortunately, these tend to relate more to Web3 native brands. So, new players that try to build a startup within the Web3 space, they tend to neglect this aspect until it's too late. So, and again, when we talk about regulatory risk, we talk about financial services, for example, securities, but also gambling. So especially if you're dealing with a video game or with a mechanic, for example, on your website that allows you to use one token and redeem another token, or you get, some sort of value, gambling becomes very relevant. And it's not often talked about, at conferences and in other places. So I would invite you, if you're building anything that has a gamified element, to really take, gambling regulation into account. The next type, if you want, of risk is commercial risk. And I'm leaning more toward the intellectual property side. So there are two main aspects, I would say, and these tend to be a risk that is often neglected from Web 2 companies or non-Web 3 companies and brands. And you'd be surprised because, of course, understanding the technology and the way that it works is paramount. One of the great features of blockchain and other form of file storage system that are often used in conjunction with blockchain, for example, to store content in the case of NFTs, like the Interplanetary File Storage System, or IPFS, means that there is an element of immutability. That means, and we've assisted clients, unfortunately, there are very large brands where they've entered into agreements with, say, Web3 companies or agencies, and they provided a license, say, for a term of 2 years. So say, random example, this has not happened, but let's say Cristiano Ronaldo gives a license for 2 years for someone to create an NFT. Say that the license is for 2 years. Well, after the 2 years, probably you're not going to be able to take down the content. So you're basically infringing by default the moment you sign the agreement because what you're signing up for is not enforceable. Another type of risk is not choosing the right licensing structure. And my colleague before were expanding on that a little bit. You have different structures. You have a traditional one where you don't give IP. You have the more, I'd say, community-empowered branding where you're giving some degree of commercial rights to your collectors. That's a great incentive, and more often than not, I don't see really a reason why you shouldn't give some commercial rights by way of license to your collectors. And then on the other end of the spectrum, you have CC0, which is great for to build up virality and becoming a brand, and leveraging more the token layer rather than the content layer in order to monetize. So by selling the NFT, building utility on top of it, redeemable merchandise, events, and so on and so forth. So commercial risk is also very interesting, and particularly in relation to the IP. But there are also other risks. For example, I'm currently working with a museum in London, and they're evaluating with which partner to enter into an agreement for this particular drop. And what's interesting is that the environment, for example, is a predominant concern for them. So you see how if you are offering Web3 services, say if you are an activation portal, or if you are providing Web2 companies, with the services to activate and enter the Web3 space, there might be other considerations. And if you neglect those are risks because they would result in something that isn't pleasant happening, and you wouldn't really maximize your chances of success. Neglecting the community is, in my opinion, the #1 fault of, let's say, non-Web3 players. Which tendency is to over-rely on marketing in order to communicate the products and services. But the product cycle in Web3 is very different because it starts with the community, and then it carries on through spreading awareness and really trying to understand what is of value to your community and how to inject that value in the token or in the NFT, or how you can facilitate that flow of value through, say, a fungible token. So how can you mitigate it? And it's like just a couple of steps. If it works. So I do think that most brands should start, whether Web 2 or Web 3, should start with the community in mind. And everyone wants to build community, but no one is a part of it. Like most of the clients that come from Web 2 and want to activate within Web 3, they are not part of the community. They don't know what it means being part of the Web 3 community, nor within a subsection of it. So create a Twitter account, start to participate. I personally despise Discord, but it's a necessary evil. And so the more you become part of the community, the more you understand what is of value to the community, what kind of rules and ethos it has. Then, of course, seek guidance and see a lawyer, because again, some risks are really hard to foresee. And I think before you build the product, you should really send a description. And I think everyone thinks badly about lawyer, and I know most of us here in the room are lawyers, but most of us are not the sharks that many expect, so you can have a call, you can reach out on the phone and have a call and just have a general chat to understand the kind of areas that you might want to consider. And that would be incredibly useful because it would open your eyes. Then, of course, as we said, the dynamics and the ethos that applies to Web3. 1 month, for example, it might be, the open edition might be a trend. The next month, open editions are bound to fail. So understanding the trend in this fast-paced environment is also very important. And then, yeah, seek meaningful partnership. Like my colleagues said before, it's a lot more, we're at a stage of the industry where partnership are more valuable than partnering up and collaborating is more valuable than competing, in my opinion. And then the last one, which seems like such a, moral-based and naive take on the industry is actually, I think, very important, which is don't consider Web3 a cash grab. And I can't stress how many athletes and person of influence wants to come in the space, just sell their token and leave. But the problem is you're ruining your reputation for a good amount of time, and it's a shame because all of these really represent the starting of this journey in Web3. But yeah, I hope you enjoyed the conversation. It wasn't anything.
Hey, thank you.